Mr. Speaker, I rise today to present to this Honourable House the report of the Special Parliamentary Committee on Customary Land and Land Reform, together with a proposed Customary Land Tenure Bill that emerges from the committee's findings. This report addresses one of the most fundamental issues confronting our nation: how Papua New Guinea protects and governs its customary land while enabling fair and sustainable development for our people. Land in Papua New Guinea is not simply property. It is identity, ancestry, spiritual connection, food security, and social stability. It is protected under our Constitution through the recognition of custom as law. Nearly 97% of our land remains under customary tenure, making our country one of the strongest customary landholding societies in the world. Across Papua New Guinea, customary land systems are deeply rooted in identity of our peoples and are governed by diverse traditions. Some communities maintain matrilineal systems of inheritance where land rights pass through the motherland. Others follow patrilineal systems where land stewardship is held through the father's lineage. Both systems are legitimate expressions of customary law and cultural identity, and both must be respected and preserved. Mr. Speaker, the challenge before us is therefore not only about land administration. It is about protecting the cultural foundations of our society while ensuring that the rights and dignity of all members of the community are respected. Mr. Speaker, yet the inquiry conducted by this committee has confirmed that serious systematic challenges exist in the way customary land interacts with modern administrative, legal, and economic systems. Across the country, we heard about historical alienation without consent. We heard about abuses associated with special agriculture and business leases. We heard about manipulated incorporated land groups, double registrations, and fraudulent land transactions. We heard about disputes that have dragged on for years, dividing clans and delaying development. Mr. Speaker, we heard about missing records, weak oversights, and fragmented institutional mandates. We heard from investors concerned about uncertainty, from provincial leaders frustrated by administrative confusion, and from public servants who acknowledge capacity constraints. Most importantly, Mr. Speaker, we heard directly from people of Papua New Guinea and landowners. From coastal communities to highland settlements, from the peri-urban corridors to island provinces, one message was repeated everywhere the committee traveled. They said, "Our land is our life." The central challenge before us, therefore, is clear. Mr. Speaker, the strength of our customary land system lies in its cultural legitimacy. Its weakness lies in the institutional systems that surround it. If we fail to address these weaknesses, Mr. Speaker, land disputes will continue to escalate, development will remain stalled, and public trust in land governance will continue to erode. If we address them wisely, Mr. Speaker, however, customary land can remain firmly in the hands of its traditional owners, while also supporting fair and inclusive economic development. At the same time, reforms must respect the integrity of customary governance structures, including the lineage systems that define land rights and social identity. The committee recognizes that protecting customary land also means protecting the matrilineal and patrilineal identities that underpin many of our clan systems. Reform must therefore strengthen these systems rather than replace them with structures that undermine customary authority. Equally important, Mr. Speaker, is the need to ensure customary land governance reflects the principles of fairness, dignity, and inclusion that are embedded in our Constitution. While customary systems must be respected, the voices of women and our young people who cultivate the land, sustain families, and inherit the responsibility of stewardship must not be excluded. Mr. Speaker, in many communities, women play central roles in food production, environmental stewardship, and family livelihoods. In some provinces, women are custodians of land through matrilineal traditions. Yet too often, their voices are absent from formal land decision-making processes. Mr. Speaker, reform must therefore protect customary systems while also safeguarding gender equality and meaningful participation for women and youth in land governance. For this reason, the committee has not only conducted an inquiry, it has also prepared a legislative proposal, the Draft Customary Land Tenure Bill, to operationalize the reform framework outlined in this report. The bill, Mr. Speaker, aims to strengthen, amongst other things, the recognition of customary authority and landowner primacy, requirements for free, prior, and informed consent, transparent clan identification and registration processes, accountable land administration and benefit sharing arrangements, meaningful representation of women and youth, the protection of customary inheritance systems, including matrilineal and patrilineal traditions, a more coherent and accessible land dispute resolutions, and quite uniquely, I add, Mr. Speaker, to promote commercial and capital development by clans and ordinary citizens of this country. Mr. Speaker, the findings presented today are not theoretical. They are the outcome of the most extensive parliamentary inquiries into land governance undertaken in Papua New Guinea in recent years. The inquiry was conducted throughout 2025 and into early 2026 through a broad participatory and evidence-based process. The committee traveled across regions of the country, around the Southern region, the Islands region, Momase, and the Highlands. Public hearings were held in Port Moresby, Kokopo, Lae, and Mount Hagen. Additional consultations were conducted through written submissions, institutional meetings, case studies, and site visits. More than 1,000 participants appeared before the committee. They included clan elders, customary chiefs, women leaders, youth representatives, land group executives, provincial administrators, church organizations, landowner associations, academics, legal experts, civil society organizations, private sector, bankers, and officials from relevant government departments. Mr. Speaker, we received detailed submissions from organized landowner associations and individual clans. We examined cases involving colonial-era alienation, peri-urban land pressure, Highlands corridor developments, and long-standing institutional disputes. The committee also undertook a comprehensive review of existing legislation and court decisions, assessed the implementation gaps of 2005 and the 2019 National Land Summits, and we closely studied comparative experiences from other Pacific jurisdictions with strong customary land systems. Importantly, Mr. Speaker, in January 2026, the committee convened a high-level national forum on customary land and human rights in Port Moresby, which, if I may add, was officiated by the good Deputy Prime Minister and Minister for Lands, Honorable John Rosso. The committee expresses great gratitude for a bipartisan approach and support. This forum brought together members of parliament, national and provincial government agencies, customary leaders, women and youth groups, academics, development partners, and representatives of the United Nations system. Proceedings were live-streamed to ensure national visibility and transparency. The forum provided an opportunity to examine the committee's findings within the framework of our Constitution and international human rights standards. It reinforced several key principles: that customary land is not merely an economic asset, but the sacred foundation of identity and community life; that reform must be grounded in bottom-up consultations, and that free, prior, and informed consent must be central to any land governance framework. The forum also strengthened national consensus around the need for clearer institutional architecture, stronger transparency mechanisms, and effective safeguards against elite capture and corruption. Mr. Speaker, this inquiry has therefore been wide in geography, broad in participation, and rigorous in analysis. It has been shaped not only by experts and officials, but by the lived experiences of ordinary Papua New Guineans across our country. We also heard important perspectives about inclusion. Women who cultivate the land spoke of their exclusion from decision-making processes. Young people spoke of losing connection to their clan land histories. Young people spoke of losing this connection, and these voices remind us that reform must not only protect land, it must also strengthen fair participation within customary systems. Mr. Speaker, the report before this House sets out a reform framework built on a number of core principles. The first is customary sovereignty and landowner primacy. Custom must remain the foundation of land governance. Number two, free, prior, and informed consent. It is understood that development must proceed only with documented and genuine consent of landowners. Number three, that transparency and accountability must be embraced. That verified clan identification, credible registration processes, and enforceable benefit-sharing mechanisms should be the hallmark of this reform. Number four, the inclusion and intergenerational equity, that women and youth must have meaningful representation. And finally, the access to justice. The land dispute resolution must be more coherent, timely, and culturally aligned. Mr. Speaker, attached to the report is the draft Customary Land Tenure Bill, presented as part of the committee's recommendations. At this stage, it serves as a legislative proposal to translate the principles identified by the inquiry into a legal framework, a workable legal framework. This bill is envisioned to establish a separate customary land authority with a board to govern the authority. The board would be constituting of a number of key government agencies and independent representatives representing women, youth, Papua New Guinea Law Society, the Papua New Guinea Chamber of Papua New Guinea Certified Practicing Accountants. This bill envisages, Mr. Speaker, to establish two registers. One is the Registry of Clans in the nation, and the second would be a register of property belonging to these clans. It envisages the formalization of perpetual land title or land interest in favor of the clans by virtue of declaration through enactment of this bill, and also the creation of subleases from the authority and the clan to third parties and land users, limited to a tenure of 50 years each. It also accommodates the creation of development agreements or subordinate agreements for development on these subject lands. These are some key features of this bill, and it also intends and allows clans to acquire the legal personality of a nominal legal entity. However, be protected for perpetually, and any enforcement of judgments are limited only to administration or receivership managers, protecting the clans not to ever be made insolvent or liquidated. So the clans will remain perpetually forever in sake of time, relative to their properties. Mr. Speaker, the purpose of today's presentation is therefore to place before this House both the findings of the inquiry and the policy direction required for reform. This Parliament now has the responsibility to consider these findings carefully and deliberate on the path forward. On behalf of the committee, Mr. Speaker, I wish to thank the elders, women's leaders, youth representatives, provincial administrators, landowner associations, churches, civil society organizations, academics, bankers and leaders of financial institutions, government agencies and development partners who contributed to this process, including those who participated in the January 2026 National Forum. Mr. Speaker, this report is not the conclusion of reform. It is the foundation of a national effort to restore trust in land governance, correct systematic weaknesses, protect our customary identities, and secure customary ownership for present and future generations of this nation. Our land is our life. If there ever were a greater call for all men and women to stand together and members of Parliament to take on this challenge, today is the hour and today is the time. It is the duty of this Parliament to protect our life and our land. I commend this report to the House